Good morning, everyone. I'm going to go ahead and call this interim meeting to order. This is the committee to conduct an interim study on issues relating to pretrial release of defendants in criminal cases authorized by Senate Concurrent Resolution 11 from the 2019 session. My name is Dallas Harris. I represent District 11, and I have the pleasure of chairing this committee during the interim. I'm going to go ahead and ask everyone at this time to silence your cell phones if you have not yet done so, so that we can keep everything moving. At this time, Madam Secretary, will you please call the roll?
Assemblyman Flores?
Present.
Assemblyman Roberts?
Here.
Senator Hammond?
Here.
Senator Scheibel?
Here.
Vice Chair Wynn?
Here.
Chair Harris?
Here. Thank you. Please mark all members present, and we have a quorum at this time. We will open up the floor for public comment, both here in Las Vegas and up north in Carson City. I can't see the audience in Carson City, but there are some people there. If anyone would like to come up and speak, please go ahead and fill up the table both up north and down here in Las Vegas. All right, we will go ahead and start with those up in Carson City. Please keep in mind that we have some limited time, and we'll also have public comment at the end of the meeting as well. Go ahead. Thank you.
Thank you, Madam Chair. Good morning. My name is Holly Wellborn. I'm the Policy Director for the ACLU of Nevada. It's a pleasure to be here this morning. I will be very brief. I just wanted to state on the record just a small bit of background on this study. I presented the bill that established this study on behalf of Senator Cannizzaro during the last legislative session. And I wanted to offer our support to this committee to provide any kind of national resources that you may need in looking at, both sides of the issue. I know that this is a very controversial issue, and that you'll be hearing from multiple sides as you study this and you proceed through coming up with the best type of legislation or package of bills to address the issue of pretrial detention in this state. So we have a network of services that can be provided in helping to assess legislation and different approaches that different states have looked at. Really what we look at as key models from the ACLU perspective is the legislation out of New Jersey. We have individuals that could speak to the committee and provide written statements on that bill. There was also successful legislation in Colorado. So if you have questions about that as you proceed through this process, I am available to you. Thank you.
Thank you, Ms. Wellborn. Go ahead. Good morning.
Good morning, Madam Chair. Tanya Brown, Advocates for the Inmates and the Innocent. You have been provided a 911 call. There's an issue with it being able to put it up on the website. I'm going to suggest, I strongly suggest that you actually listen to the 911 call. Mr. McCarter is down in Las Vegas. He will be testifying. This is a 911 call that pertains to him and his situation. He also has a copy of the transcripts of the 911 call. The thing is that if you read the transcripts and you don't listen to the 911 call, you don't have an understanding, an accurate understanding of what actually transpired. The 911 call is very telling and actually supports Mr. McCarter, who was arrested, was in jail until he was able to bail out, and he's about to stand trial. And some of these charges, if not actually none of the charges, he should have been charged with. So he can explain that because I'm going to have to leave here pretty soon. I've provided you with a copy, which I believe is instrumental in getting a better understanding of what we're dealing with, and I'll just briefly read it. I base this on not just my personal situation, but others as well. It's dealing with discovery, and I think we need to change that. And what I'd like to see is once a defendant is arrested and charged with a crime, the reporting law enforcement agencies must provide to the defendant and to his or her representative with a copy of all the materiality and exculpatory evidence that was disseminated to the district attorney and is now in the possession of the district attorney within 3 working days. Any additional copies of materiality and exculpatory evidence that is provided to the district attorney, whether it be the law enforcement agency or the district attorney's own investigator, the evidence must be provided to the defendant and his or her representative within 3 working days of receiving such evidence. Discovery is turned over after a person is charged and arrested, but there has been times where discovery is never turned over until just prior to the trial, the day of the trial, even years after the trial. This needs to stop. If you change the rules of discovery and allow the law enforcement agencies to turn over the evidence, the same evidence that was provided to the prosecution, it will level the playing field of any prosecutor withholding evidence from the defendant. And it gives the defendant the opportunity to see the evidence prior to at trial, if he ever sees it at all. It will save the taxpayers monies because now we are not incarcerating a person in jail because they could deal with it a lot sooner, get them out sooner on bail, if bail at all, if not exactly, if not even exonerate the individual. I refer to this as Nolan's Law. I base it on what happened in my brother's situation, so I refer to it as Nolan's Law. And I believe that if by doing this, this would be, the first in the country. Thank you.
We have 3 more people here
Thank
who'd
you.
like to speak. I appreciate your time. Thank you so much. And just so you know, we do have that transcript. It will be available online, and I believe the audio will be provided to the members of the committee. We will be going into a little further discussion about this later on in the day, but discovery may be slightly outside of the scope of what this committee will be examining, but I appreciate your comments, and we will take that under to consideration down here in Las Vegas. Good morning.
Good morning, committee. My name is Christine Saunders, and I'm the Policy Director with the Progressive Leadership Alliance of Nevada, and I'm glad I'm able to join you all in person today. Ending cash bail has been a priority of Plan members, and we put a great deal of effort into it during the past legislative session. At Plan, we believe that the closest to the issues are the closest to the solutions. It is important that directly impacted people from the community be an equal partner with this committee. Plan is happy to be a conduit for the committee to engage community members as well as provide any additional resources, and we look forward to working with you on this process. Thank you.
Thank you.
Hello, my name is Roy McCarter. I'm a veteran of the United States Army. I'm also a former California correctional peace officer. I moved to Las Vegas in 2013, started a business, and changed, turned my life around. Just recently, I have a daughter who's 25. She's mentally ill, and she's also addicted to methamphetamine. About March 27th, she and her boyfriend fabricated a incident that I had a knife and that I attacked them and threatened to kill them. Okay, and that's impossible because I called 911 at 11:07 and 13 seconds. I'm on the phone with dispatch. She opens the door, and I tell dispatch Peralta, ma'am, my daughter just opened the door. They're asking me to leave the residence and wait outside for the police to, make sure it don't escalate. So that's what I do. As I'm exiting the door, I see her boyfriend standing behind her. Now, he threatened to kill me, and I filed a police report, and he's been trespassed from my residence. Okay? Nevertheless, when I went outside, I'm on the cell phone with 911. Okay? My daughter had called 911 after I did at 11:08 and 41 seconds. So it's impossible for the crime to have occurred. If it did, it would have been recorded. I'm on the phone with 911 from 11:07 and 13 seconds till they arrest me. I'm standing in front of my home talking to the dispatch when Metro pulled up. And that's when they shined a light on me and told me to hold my hands up. At that point, they seized me at gunpoint, okay? And I also sent you that video. It's petrifying to watch. You know, I see men like myself murdered in the United States on the regular. And my daughter, this is what she intended to happen to me, okay? And I feel the police didn't do a good job at all investigating, because had they did, they would have discovered that this is a prank call, okay? And what Ms. Brown was suggesting, had this been in place, I wouldn't be here right now, because that 911 tape would have been available at the preliminary hearing. It wasn't. So they found probable cause for what I called a hashtag Tooth Fairy crime, because it's impossible for it to have occurred. And so all I'm asking this committee to do is listen to that tape, listen to the tape. There's nothing else to talk about what he or she said, because the 911 tape is it. It's impossible for that crime to have occurred. I spent 6 months in jail, and that's when I was on the kiosk and I discovered an article from the ACLU, and it mentioned Ms. Brown's brother, and that's how I reached out to her. And ever since then, when I bailed out, I went pro per. And when I went pro per, when I got that discovery, I discovered that I made the first call. They told me that my daughter called first. They wouldn't get the evidence from California regarding her. She was in foster care there. When I went pro per, it took me 1 week to get those files. It took them 6 months, and they never got it. So again, if that evidence is provided immediately to the defendant, I could have easily defended myself. I lost my home. I lost everything. I have nothing. I moved back to California to a friend's house now. And I drove here from Imperial, California, about 3.5, 4 hours. So I had no rest, but this was a very important meeting for me today, and I really appreciate you giving me this time today.
Thank you for your time and for your service. I know we all appreciate it, and as I mentioned, we do have access to that information. I appreciate you being here. Thank you.
Good morning to the committee, and thank you to Chair Senator Harris and all the members of the committee for the opportunity to be here this morning. My name is Mark Ebel, and I direct the legislative affairs for a holding company that operates Aladdin bail bonds, and also the surety Seaview that underwrites those bail bonds. We operate here in Nevada, but we also operate across 9 different states, heavily weighted on the west, but also 2 states recently on the East Coast. By virtue of operating across the U.S., it gives us the opportunity to see this issue from a very broad perspective. And I noticed on the agenda, national trends was on the topic today. The trend is that most, if not all, states are having this conversation. But the trend sort of stopped there because the conversation looks much different in all different states. You know, each state is unique. And so the solution that states are implementing is the whole spectrum of different solutions for this issue. The states that we see operating or doing this successfully without intense public blowback or unintended consequences start from identifying what problem are you trying to solve for, and then is there data that exists that defines that problem. And in my conversations here in Nevada, I understand that some of that data does exist, and we just hope to be a partner in you guys' efforts going forward. We can be of any use in terms of other conversations, other solutions that states have implemented. Happy to be of service, and thank you again for the time to be here this morning.
Thank you. Is there anyone else up in Carson City or down here in Las Vegas who'd like to give public comment at this time? Okay, seeing none, I will go ahead and close agenda item number 3 and open up agenda item number 4, opening remarks. As I mentioned, my name is Dallas Harris, representing District 11. That's in the southwest part of Clark County. And it is my pleasure to chair this committee. I'm hoping that some constructive solutions can be found, and that we can find a way to make the system safer and overall operate just a little bit better. And by that I mean efficiency as well as accuracy, right? The goal is to make sure that those who don't need to be behind jail, behind bars, shouldn't be, and those that do need to be behind bars should be. And the closer we can get to making that happen, the better we all are off. So that's what I'm looking forward to, and my goals. At this time, I'm going to ask the committee members to introduce themselves, and if they so choose, maybe discuss a little bit about what they're hoping to get out of the committee. Vice Chair Wynn.
Hi there. Hi there. Sorry, it's been a while since I've had to push a mic every time I talk. My name is Rochelle Wynn. I'm the Assemblywoman for District 10 here in Las Vegas, and I am the Vice Chair of this committee. I am looking forward to this. As many of you know, I do work privately in the field of criminal defense work, so I have personal and professional knowledge of some of the issues that we're hoping to tackle here, and I'm optimistic we will be able to come up with solutions.
Good morning. My name is Senator Scott Hammond. I represent Senate District 18. This is obviously an important issue enough that we've had several bills. Looking forward to kind of going through the data and really trying to find out what the purpose is, what do we want to accomplish, and then look at what the data is telling us here in the state of Nevada, and to find that balance that was spoken of by the ACLU representative this morning, Holly. Again, grateful to be here and serving with these fine folks.
Good morning, Assemblyman Tom Roberts, Assembly District 13 here in Southern Nevada. 34 years in law enforcement, so I have been involved in the criminal justice system most of my life, and so I hope to bring that experience and background to this process. And as mentioned before, you know, there's a movement across the country to make changes to bail and pretrial release, and you know, I think Nevada is no different. I think we need to be forward thinking on this, and I love to come up with some solutions that will provide some safety and common sense and good for all. So look forward to it.
Good morning. I'm Senator Melanie Scheibel, also from Las Vegas, from Senate District 9, which is just a little bit further south and a little bit further west than Chairwoman Harris's district. And in my day job, I'm a prosecutor, so I also have extensive experience with the pretrial release statutes and with taking on those questions of how we allow people to exercise their freedom and liberty while they are awaiting trial and protect the community at the same time. So I'm looking forward to what I'm sure will be a robust conversation in this study, and hopefully we come up with some good outcomes and solutions for moving forward.
Good morning, everyone. I am Assemblyman Edgar Flores. I represent Assembly District 28. I'm not sure this is capturing my voice here. I need to get closer. I just look forward to working with all the stakeholders. In my private life, practice immigration law, and the intersectionality between criminal law and immigration law is very unique and impacts folk in a very different way. Often, some folk don't have an opportunity to conclude what happened in the criminal world because they may be removed from the country prior, and sometimes there's for charges that they're not even ever found guilty of. So I look forward to working with everybody and finding out how we can work together and changes that will hopefully help some of these folks.
All right, thank you, committee members. As most of you are, if you're familiar with the Nevada legislature, you know we have an awesome staff at the Legislative Council Bureau, and we are very fortunate to have Nicholas Anthony, who is a Senior Principal Deputy Legislative Counsel, as my legal advisor here on this committee. We also have Kathleen Norris, who is a Deputy Legislative Counsel. And our secretaries for this committee will be Ms. Angela Hartzler, as well as Mr. Jordan Haas. So thank you to LCB staff for all the work that you've already done, and for the lot of work I anticipate you'll be doing moving forward. Thank you so much. With that, I'll go ahead and close agenda item number 4 and open up agenda item number 5, which is an overview of Senate Concur Resolution number 11 and the committee's duties and timelines. At this time, I'll turn it over to Mr. Anthony to give us an overview.
Good morning, and thank you, Madam Chair and members of the SCR 11 Committee. I'm Nicholas Anthony, nonpartisan staff from the Legal Division. Will be serving, it's my pleasure to serve as primary staff to this body this interim. As Chair Harris noted, we also have Kathleen Norris, who will be assisting me, as well as our two secretaries, Ms. Haas and Ms. Hartzler. And so members of the committee may be getting emails from any or all of us with information and updates about the committee, polling times, places, locations, etc. If you should have any questions, please feel free to reach out to me at any time. With that said, I'll quickly just provide a brief overview of SCR 11. That is enabling legislation for this interim study. SCR 11 was brought forward last legislative session, the 2019 session, and it created this 6-member body, 3 senators and 3 assembly members. The duties of SCR 11 are spelled out in the legislation. They are 9-fold. They are to study the timeliness and conduct of hearings for pretrial release, release on own recognizance, or OR, the use of monetary bail, pretrial release to ensure the safety and appearance of the defendant in court, modifications of the conditions of pretrial release, the use of the Nevada pretrial risk assessment tool, which will be talked about a little bit later. It's currently being implemented by the courts. The impact of race, gender, and economic status as it pertains to pretrial release, the fiscal impacts of any potential or recommended changes to pretrial release, and any other matters this body sees fit as it may relate to the pretrial release of criminal defendants. Voting and requests for legislation, SCR 11 is very clear in that if this body chooses to move forward with a bill draft request, it does require a majority of the members from each house. So it would take 2 senators and 2 assemblymen to move forward with a BDR. The committee is allotted 5 bill draft requests this interim, so should you see the need to move forward with a bill draft request, this body does have 5 at their disposal. The deadline for those is they must be submitted to the Legislative Council by September 1st of 2020. This body has a budget of approximately $6,000, which will take care of legislators' staff salaries, per diem, travel expenses, etc. It's anticipated that this will allow for 4 meetings this interim. Today, an introductory meeting with 2 substantive meetings, followed by a work session to be scheduled sometime this summer. Possible actions at that work session, typically that's when this body chooses to take action, and the actions are to request a BDR, to include a statement in the final report, or this body can direct staff to prepare a letter on behalf of this body to, say, an interested stakeholder, agency, another branch of government. During the fall and after the conclusion of this committee's work, staff will work diligently to prepare a final report. We will draft up any potential BDR recommendations and submit those all to the 2021 legislature. And with that, Madam Chair, I'd be pleased to answer any questions.
Thank you, Mr. Anthony. Are there any questions from members at this time? Okay, great. Well, we'll just keep it moving right along then. We'll go ahead and close item number 5 and open up item number 6, which is an overview of pretrial release measures from the 2019 legislative session. We have Ms. Kathleen Norris here. Go ahead and start when you're ready. Thank you.
Thank you, Madam Chair. Kathleen Norris, for the record, from the Legal Division. So this presentation is going to give you a 10,000-foot overview, a quick synopsis of 3 bills that did not pass in the 2019 legislative session. Those bills are AB 125, AB 203, and AB 325. I just want to note that these bills specifically deal with procedural policy relating to the pretrial release of defendants and don't deal with peripheral bail issues such as the licensing of bail agents, etc. Attached in your materials, you all should have gotten it, is a chart that covers these bills in significantly more detail, as well as the text is on Nellis online for your view. So AB 203, that's what we're going to start with. It deals with releasing defendants on an unsecured bond. So this bill states specifically that if a defendant can be released without seeing a magistrate, then the person must be released on an unsecured bond. And it specifically limits these defendants to those who were arrested for a misdemeanor or gross misdemeanor that does not involve an act of violence, who was not arrested while on bail, and who does not have a history of failing to appear while released on bail or released without bail. The next two bills are AB 125 and AB 325. These bills, I want to note, overlap in some capacity, whether the provisions are verbatim or similar. So I'll be noting those provisions in my discussion of AB 25, but these are not the same bills, so don't think that you can just read one and it's exactly the same as the other one. So AB 125, that's what we're going to start with. It prohibits the modification of an original determination of bail under certain circumstances and requires a prosecutor to file certain motions prior to wanting to modify the bail under those circumstances. AB 125 specifically talks about an administrative order, and it requires courts to adopt an administrative order for the release of certain defendants. So it covers the conditions of that release for gross misdemeanors, misdemeanors, and felonies, and how those individuals will be released, but it doesn't holistically cover who will be released. So crimes such as those involving domestic violence, etc., those are not covered under this automatic release for the administrative order, so you kind of need to read that in more detail. AB 125 specifically creates a rebuttable presumption that defendants should be released on their own recognizance and that monetary bail should not be imposed unless absolutely necessary. AB 125 requires defendants to be seen within 48 hours of being taken into custody for a pretrial release hearing to determine the conditions of their release, and the bill sets forth the priority of conditions of release, starting with OR and moving down to significantly more conditions of release being necessitated, So AB 125 and AB 325 specifically remove monetary amounts of bail required for certain domestic violence offenses and certain certain violations of temporary and extended orders of protection. So in the law now, it says certain monetary amounts. Those are completely deleted, and it's up to the pretrial release hearing to determine those. In terms of revocation, revocation of bail can only be imposed for certain offenses, such as those involving domestic violence and violations of certain orders of protection. AB 125 also makes robust changes concerning magistrates and how they handle bail. So, for example, it authorizes magistrates to be allowed to modify bail. It also states that magistrates can only impose monetary bail if no other conditions will ensure the appearance of the defendant. The amount must be based on the financial resources of the defendant, and the magistrate makes specific findings of facts concerning community safety and the ability or the likelihood of appearance of the defendant. Finally, AB 125 prohibits detention of a defendant solely because they are unable to pay their monetary bail. So as I said before, a few of these provisions are seen in AB 325, and those include the modification, prohibiting the modification of an original determination of bail, the orders of priority of release, deletion of the specified monetary amounts of bail for domestic violence offenses and those pertaining to protection orders. The revocation of bail is changed in AB 325 as well, and those pertaining to magistrates. So now we'll move on to AB 325, and these provisions are only in AB 325, so I just want to note that for the record. AB 325 requires the pretrial release of those defendants who are constitutionally eligible with the least restrictive conditions necessary to ensure their appearance. It prohibits the imposition of financial conditions, arrest warrants, or other contact with the criminal justice system beyond that of an unsecured or secured bond if absolutely necessary. With regards to misdemeanors, AB 325 requires that those defendants charged with a misdemeanor be released on their own recognizance and with no other conditions beyond that stating that they can't commit a new crime. They have to give certain personal information to the court so that they can be contacted and that they stay away from the victim if that's applicable to their charged crime. For felonies, AB 325 requires a pretrial release hearing within 48 hours. It also necessitates that those charged with a felony be released on the least restrictive conditions necessary to ensure their appearance. With regards to this pretrial release hearing, it's an extensive list of the procedural posture of this hearing, the rights of the defendant, and the duties of the prosecutor in the court. Those are all explicitly set out within AB 325. Within AB 325, law enforcement is also allowed to release a defendant prior to their pretrial release hearing and sets forth the conditions of that posture. With regards to offenses for being under the influence of alcohol or a prohibited substance, certain domestic violence offenses, and violations of certain orders of protection, AB 325 limits the detention of these persons for 4 hours. So this is limited from a 12-hour period, or there was a different period for being under the influence of alcohol or drugs. So this is changed to 4 hours across the board for these offenses. Finally, AB 325 states that if a defendant fails to appear, the court must attempt to contact the individual with the contact information they were supposed to give to the court. And AB 325 also makes a number of changes relating to bail requirements for a material witness, which is kind of a peripheral issue to what this committee is looking at. So as you can see, these are a lot of changes. I covered them very quickly, but I'm happy to answer any questions if you have any.
Thank you so much, Ms. Norris. I appreciate your diligence. This is very helpful. And I believe Vice Chair Nguyen has a question.
If you recall, I don't recall. Do you know if both the previous submitted bills that we just talked about, did they all utilize the pretrial risk assessment, or was that not included in some of these bills? I'm just trying to remember. If you remember.
I don't recall. I don't think it was mentioned.
Are there any other questions from committee members for Ms. Norris? Okay, thank you so much. We'll go ahead and close out agenda item number 6 and open up number 7, which is a presentation on national trends in pretrial release of criminal defendants. We have Ms. Widgery, is that correct, from the National Conference of State Legislatures. Thank you so much for traveling here to Nevada to go ahead and give us this overview. We appreciate you coming all the way from Colorado. And go ahead and start when you're ready. Thanks so much.
Yes, thanks, Madam Chair. I'm happy to be here. I just had a quick question. Do you all have access to my slides before I begin? Perfect.
We do, yes. Thank you.
All right. I didn't know. Are they? Okay. now I think we're settled, so everyone else can see too, maybe. So again, I'd like to thank the committee for inviting me here today. My name is Amber Widgery, and I'm a Senior Policy Specialist within the Criminal Justice Program at the National Conference of State Legislatures. For those who may not know, NCSL is the bipartisan organization for the more than 7,000 legislators and more than 30,000 legislative staff from the states, commonwealths, DC, and U.S. territories. And at NCSL, I track pretrial policy developments in addition to other criminal justice policy areas. So to sort of frame the issue, the most recent data we have from the Bureau of Justice Statistics estimates that about 65% of jail inmates are actually individuals awaiting court action on a current charge or being held pretrial. That same data has been examined by the Prison Policy Initiative, and when you eliminate individuals within that data who are being held not for the local jurisdiction but being held for another agency, that estimate pushes to around 76% of jail populations who are being held pretrial. Pretrial policy can be broken down into a number of smaller subtopic areas. Those are listed on the screen. I highlight that because these are the areas of information where NCSL has 50 state data. We have web pages that are interactive that you can view on each of these pretrial policy subtopics if you're interested. I'm not going to be covering each of these topics today because that would take an exceptional amount of time, but do know that we have those resources available online, and I'm happy to answer any questions that you may have after today's hearing. To briefly overview, NCSL started tracking pretrial legislation in 2012, and since that time there have been nearly 1,000 enactments in each of the 50 states. Preliminary 2019 analysis shows that we'll have an additional 160 enactments in 2019. Successful legislative efforts to change pretrial policy have largely been bipartisan, and recent polling supported by both the Charles Koch Institute and the Pretrial Justice Institute shows that a majority of Americans favor ending the practice of jailing people who cannot afford money bail in all but the most extreme cases. Overarching themes for legislation have centered on two things. One, reducing the number of individuals who end up in the pretrial system who might be better served outside of the criminal justice system or through another means other than the traditional booking process. And also on moving pretrial policy away from charge-based bail schedules and monetary decision-making frameworks towards decision-making models that focus on limiting detention and mitigating defendants' risk of non-appearance or rearrest. So I put up that list earlier of sort of the complete areas of pretrial policy that NCSL has information on a 50-state basis, but today I'll be focusing on sort of the national trends where we've seen the most legislative focus. The first policy area that I want to address is pretrial risk assessment. Between 2012 and 2018, 29 states enacted 58 new laws related to the use of pretrial risk assessment. Nearly every one of these enactments has regulated, promoted, or required the use of a risk assessment. Iowa, as you see on the map, is the sole exception, where legislation this last year actually eliminated their pretrial risk assessment pilot programs. To give the national overview of where we stand currently, there are 7 states that have legislatively required courts to adopt and or consider a pretrial risk assessment in at least some cases. There are usually exceptions if a pretrial risk assessment would end up requiring a person to stay in an incarceration setting longer, then they'll skip the assessment and move beyond that. An additional 8 states have passed legislation that authorizes or encourages but does not require the use of a pretrial risk assessment on a statewide basis. Note that California is not actually reflected on my slide because their enabling legislation was enacted in 2019, but California should be added to that middle list. And an additional 5 states, including Nevada, have adopted a system of pretrial risk assessment on a statewide basis through judicial action. Not included on this list of the current status of risk assessment across the 50 states are states who have appropriated funds to assist in the development of pretrial risk assessment pilot programs or pretrial risk assessment tools themselves. There are more than a dozen pretrial risk assessment tools in use across the United States. The publication I've highlighted on the screen is available online and is a good overview of the tools themselves and the best practices associated with implementing them. It also addresses key issues that have been raised when implementing pretrial risk assessments, and I highlight a few of those key findings from the report on my slide. The first finding that you see is that a risk assessment tool can inform but should not replace judicial discretion. Alaska is the only state that has ever tried to mandate through legislation strict adherence to a risk assessment tool, but that provision was repealed almost immediately before it was ever implemented. Other legislation has, in fact, done the inverse, which has required courts to consider more than just the results of a pretrial risk assessment when determining release and conditions for individuals. The last two considerations on this slide are about the quality of data, appropriate use of the tool, and validation on the population for which the tool is going to be used. These considerations have also been of particular concern to lawmakers, and this is reflected in more recent legislative enactments addressing pretrial risk assessment. Recent actions have required that a tool be empirically developed, required that tools be validated and regularly revalidated. Actions have required courts to develop guidelines for the use of an assessment. They have required standardized assessment use across the state. They've required that assessment data and validation data be publicly available. They have required that individual defendants have access to the data that was used for their assessment to ensure accuracy. They have prohibited the use of proprietary tools, and most recently they've required that any tool adopted by a court be free from racial or gender bias. Here are a couple of recent examples. Legislation in California, Idaho, and New York are all recent examples of a sort of more current risk assessment legislation that has focused more on regulating the use of risk assessments and less on mandating the use of risk assessments. In addition to addressing the use of risk assessment tools, state legislatures have also limited courts' ability to impose financial conditions of release in certain circumstances. Currently, every state statutorily authorizes the use of financial conditions of release in some, if not all, cases, even if the use of financial conditions has been essentially eliminated in practice. DC and New Jersey are both usually cited as examples of jurisdictions where the use of financial conditions in practice has been substantially limited. California is the only state that has legislatively tried to eliminate financial conditions in its entirety, but the fate of Senate Bill 10 will be decided by the voters in California this November, so its implementation is currently on hold. As I mentioned, other legislative actions have limited but not eliminated financial conditions of release. This has included codifying presumptions of release on recognizance, codifying presumptions of release on least restrictive conditions, limiting or prohibiting financial conditions in specified cases, requiring courts to consider ability to pay financial conditions of release and other supervision costs and fees that might be associated with other conditions, and creating or speeding up second look or review situations in cases where a defendant has been set conditions but is unable to meet initial conditions as set. Nearly half the states now have a codified presumption of release on non-financial conditions. I've also highlighted a few recent examples of significant state action in this area. Last year, Colorado prohibited the use of financial conditions for most traffic and petty offenses unless payment of a financial condition would actually expedite the release of an individual. New York has perhaps been the most significant legislation restricting financial conditions of release by eliminating financial conditions for nearly all misdemeanors with a few specific carved out exceptions, and also most nonviolent felony cases, again with a few specific carved out exceptions. In other states like Connecticut or Texas, there has been a prohibition of the use of financial conditions of release for certain types of cases unless a defendant has requested a financial bond or if the court makes certain findings on the record that no other conditions of release would be sufficient to ensure a defendant's appearance. As I mentioned earlier too, one of the trends has been considering a defendant's ability to pay when setting any financial conditions of release. And legislation in some cases has prohibited courts from imposing any condition of release that would result in detention because of inability to pay. A number of recent state examples are highlighted here, but this has certainly been a trend over the past 3 years. I should also highlight that New Mexico's recent constitutional amendment gave the courts the authority to detain individuals based on risk and not charge, but also added a constitutional provision that prohibits a detention of defendants because of an inability to pay a monetary bond condition if the defendant has been determined to be neither dangerous nor a flight risk. There are just a few more examples that are more recent of ability to pay consideration determinations. I also mentioned the trend of creating a presumption of release on the least restrictive conditions. This is a presumption that has been codified in 19 states. You'll notice that I say 19, not 18, which is what it says on my screen. The map on the screen does not yet reflect the 2019 New York enactment. An additional 4 states that you see in yellow also have created a hierarchy of release conditions in lieu of the presumption that would require courts to start with the least restrictive, usually a release on own recognizance condition, and then work up from there in terms of restrictiveness of conditions. Another policy that has gained legislative attention is codifying a process for review of release conditions if a defendant has been unable to meet them. Specific process varies from state to state, but I've included a few recent examples here on this slide. Recent legislative trends have generally shortened the period that lapses before review occurs or has provided guidance on how to alter conditions that are preventing the release of an individual defendant. Legislative actions have also targeted conditions of release that have been codified in a state. Recent enactments have been largely diversifying conditions that are available to a court. Between 2012 and 2018, 43 states enacted 151 new laws modifying the statutorily listed conditions of release in some manner. On the screen, you will find the majority of conditions that are listed in statute in all 50 states. In addition to these statutory conditions, all but a handful of states also authorize courts to impose any conditions necessary to ensure appearance or ensure public safety, allowing courts a considerable amount of discretion to tailor conditions to aid a particular defendant in remaining compliant with pretrial procedures. If you are interested in statutory conditions across the 50 states, NCSL has an interactive database where you can go through each of the 50 states and look at the statutory conditions, including states that authorize any conditions the court deems necessary. And the link is available through my slides, so you can click through on the online version. One increasingly common condition of pretrial release for moderate or high-risk defendants is supervision or check-ins with a pretrial services program. Between 2012 and 2018, 30 states enacted 87 new laws addressing pretrial services programs. Notable state legislation has created or authorized new statewide pretrial services programs to address and to assess and supervise pretrial populations. State actions have also authorized local pretrial programs, incentivized the creation of local programs, or authorized the use of state funding for pretrial programs. Alaska, Kentucky, and New Jersey are all notable for having state-level agencies dedicated to pretrial services that assess and supervise defendants on a statewide basis. The majority of states currently use pretrial services programs to some degree. The 3 statewide agencies are of note, but certainly local jurisdictions have been putting in place pretrial services programs on their own with or without state support. Recent legislation has also gone beyond supporting or creating infrastructure of pretrial services programs and has, as of last year, specified the use of certain pretrial supports. Legislation in 2019 in both New York and Colorado has required the implementation of statewide court reminder systems. Reminder calls are one part of pretrial services that can generally be implemented at low or no cost and have been supported by robust research as being highly effective in increasing pretrial success rates. Recent legislation has altered frameworks of who is eligible for pretrial release. Between 2012 and 2018, 33 states enacted 84 laws that changed the substantial framework for who is initially eligible for release at pretrial. A good deal of this legislation has addressed those short-term holds or short-term denial of release. This includes cooling off periods for domestic violence cases or other short-term holds where there are possibly substances that are involved and it would be unsafe to release a defendant. However, New Jersey and New Mexico have both amended their constitutional language in the last 10 years, substantially changing the foundation of who is eligible for release. Courts in each state are now authorized to detain individuals based on risk and not just charge. The role of victims in the pretrial process has also been of great concern for policymakers. The majority of states gives victims the right to be notified of a defendant's release pretrial, and the majority also have a law addressing victim participation in the pretrial release process, whether that is the opportunity for input or the opportunity to consult with a prosecuting attorney varies by state. Between 2012 and 2018, 39 states enacted 106 new laws addressing the role that victims play in the pretrial process. A handful of states have also amended their constitutions by adopting Marsy's Law. Those states that have adopted those constitutional provisions, generally one of those provisions is that a court or release authority has to consider a victim's safety when making a release determination. So that's another area that constitutional frameworks have been modified specific to victims' role in the pretrial process. Citation in lieu of arrest is of interest to states. There have been 23 new laws between 2012 and 2018, but possibly more significantly is that citation in lieu of arrest has been significantly expanded on a local law enforcement level. The use of citation in lieu of arrest is authorized in every state. Most state laws focus on low-level offenses only, but at least 8 states allow the use of citations for at least some specified felonies. An additional 7 states provide general authorization for the practice, but do not specify any restrictions based on charge or type of crime. And as I mentioned, even where legislation hasn't been changed, we've seen a substantial amount of focus at the local level to reduce the unnecessary use of jail for an individual who could easily be cited into court and successfully appear in court and abide by all conditions associated with the citation instead of proceeding through a traditional booking process. In the same vein, states have also been looking to deflect individuals away from the pretrial system and the criminal justice system as a whole. Deflection is an emerging legislative trend that broadly reroutes individuals away from the justice system before either the first point of contact or before arrest. This is a more emerging area of the law for state legislative attention, whereas there has been a lot of local development on the ground at the agency and local level. Alternatively, states have also been looking to expand their pretrial statutory diversion programs. This can be in the form of treatment courts or other court-based options, pre-adjudication, where an individual who successfully completes the pretrial diversion program would then not end up without a record, and then thereby increasing their chances of success going forward and also remaining out of the criminal justice system. 48 states and the District of Columbia have pretrial diversion programs in place, whether those are treatment courts or specific programs that are run by the courts or generally prosecuting attorneys or the other administrative agency. And this is a well-established area of the law, but recent trends have focused on broadening who is eligible and removing requirements for pretrial diversion. I wanted to highlight a few examples of local deflection programs and give you a broad definition for deflection because it is such a new area of legislative focus. Sort of alphabet soup, everyone has a different acronym for their program that is designed to meet the needs of their local community, but some of the ones that you may have heard are, say, LEAD, Law Enforcement Assisted Diversion, or the ANGEL Initiative, which was implemented on a statewide basis in Kentucky but started in Massachusetts. There are a handful of legislative enactments that focus on deflection on a statewide level. Most of these have been appropriation of funds to assist the development of pilot programs or study the efficacy and effectiveness of pilot programs. Illinois is probably one of the more substantial pieces of legislation that we've seen that authorizes 5 separate deflection pathways on the front end of the system to divert individuals away from the criminal justice system and from the pretrial process as a whole. And then if you have questions about pretrial diversion, statutory diversion, either diversion programs that address general populations without having specific requirements related to substance use, mental health, veteran status, or other. NCSL has a database with that information. We also have a database that has information on specific pretrial diversion programs for those individual identified special populations as well. And I think I will wrap up there and ask if you have any questions, because I think that is a lot of information that I've just put out there.
Senator Scheibel.
Thank you, Madam Chair, and thank you for that presentation. It was very informative, very helpful. I kind of want to go back to something that we touched on at the very beginning. I'm trying to find which slide we were looking at. It looks like about your third slide regarding the percentages of people who are in jail at any, that slide. Nope, the one right after that.
Yep.
So if I'm understanding this right, this is jails and not prisons, right?
Correct.
And so this is supposed to tell us how many people in the local jail are awaiting trial versus how many are serving a sentence.
Correct.
And what is it that we're supposed to glean from a high number of pre-trial detentions or a high number of people serving sentences, presumably on misdemeanors?
I'm not sure that NCSL has any sort of comment on the data in terms of what the takeaway is, other than jail growth nationally has largely been driven by the increase in pretrial populations. I maybe should have added a slide showing the increase over the years in jail populations, and the increase, particularly in the pretrial population, has driven jail growth. But I'm not sure NCSL would comment any other than it's been driving the overall growth of jails nationally.
So that growth is both in terms of the number of people who are in jail and as a percentage? Is that what you're saying?
I believe so. I would have to double check the data, and I can certainly get that to you. But yes, overall jail growth and percentage overall.
So you're saying that like 10 years ago, it might have only been 50% of people in jail were awaiting trial, while the other 50% were serving their misdemeanor sentence. And now we're seeing that 75% of people in jail are waiting trial, but only 25% are actually serving a misdemeanor sentence.
Madam Chair, I would have to pull the data to be certain, and I would be happy to get that to you, but my understanding is yes.
Okay, thank you.
Any other questions from members? Vice Chair Nguyen.
Thank you. When I'm looking at some of these common statutory conditions of pretrial release, are there any links, or do you have any data that suggests that any of those things are actually effective? I know that sometimes people use them, but I don't know if there's any data to suggest that having someone on house arrest or any of those electronic monitorings are even effective at keeping the community safe.
Madam Chair, if I may answer. Assemblywoman Nguyen, we unfortunately don't have a lot of robust research on which conditions are the most effective at ensuring either appearance or public safety. I mentioned court reminder calls because that is one of the few, not necessarily conditions of pretrial release, but one of the few pretrial release mechanisms where we do have data showing that there can be an increase in ensuring defendant compliance with pretrial conditions and making sure that they do appear. But unfortunately, there's not a lot of data. And in fact, some limited data showing that overconditioning a defendant might in fact set them up to not succeed.
Senator Scheibel.
I have a follow-up question about the reminder calls. Do we have data on how that is effective for pro per defendants as opposed to defendants represented by attorneys?
I'm not sure either of the studies that come to mind off the top of my head in Colorado or Nebraska differentiated between either of those populations, so I'm unaware that that's been something that's been, but there might be. I can look at the data and get back to you.
So it may be possible that if attorneys called their clients before court more often, that they would have better compliance?
Possible, but unaware that there was any differentiation in the data. I think the programs that have been studied call everyone, and so there's been no differentiation between populations to study that divergence that might exist.
Assemblyman Roberts.
Thank you, Madam Chair. Just a quick question is, thank you for the presentation. NCSL is a very good resource. Do you have any data to where some states implemented reform or some steps and then actually maybe went backwards and repealed some of the things that it wasn't actually such a great idea? Do you have any of that to where things have kind of moved one way and kind of went backwards?
Madam Chair.
Not necessarily backwards, but adjusted.
I think Alaska is the most recent example of a state that has put in place substantial pretrial reforms and then walked back some of those reforms. They maintained the majority of their pretrial reforms overall, but certainly made some adjustments after recognizing that their system, for example, didn't take into account out-of-state convictions when evaluating defendants. And so there have certainly been states that have reevaluated and made changes to legislative reforms in the area of pretrial release. But overall, I would say the trend has not been for states to sort of walk back after implementation. But there has certainly been follow-up legislation in nearly every state. Colorado comes to mind, New Jersey comes to mind, Alaska also comes to mind, where there have had to have been follow-up legislation to ensure implementation was being carried out with the initial intent in mind of the initial legislation. So.
Vice Chair Nguyen.
Sorry, I have a lot of questions. In some of the studies the data that you're pulling, are the collection of any of the data that we have, does it distinguish between like felony or pretrial arrests and misdemeanors? I know that we have like a pretty like strong like municipal like jurisdiction that only handles with misdemeanors, and in the past we've kind of carved them out, but I was wondering if these numbers and the statistics that you presented today include those.
I guess I would, Madam Chair, ask which specific statistics you're asking about, and I could look at that more individually. I know that other states are similarly situated and have sort of different courts with jurisdiction that address different levels of offense. Texas is one of those examples, and legislation has addressed each sort of different level of jurisdiction, specifically with pretrial release. But I would ask for maybe additional clarification.
That kind of answers my question.
Okay.
Thanks.
Assemblyman Flores.
Thank you, Madam Chair, and thank you for that presentation. I'm looking at the slide number, and I apologize for not having, I don't know what number it is, but I'm looking at it's figure 1, the Bureau of Justice Statistics for 2017. It was right before, yeah, that's what I'm looking at there. So I'm looking at this figure here, and I'm trying to understand two things. Number one, it seems like it's pretty consistent with the exception of 2007 and 2008. It looks like we had an increase in folk that were incarcerated or in prison, in jail, excuse me. And what I'm trying to understand is I'm looking at 2016, 2017. Now, this trend of trying to move away from find alternatives, better said, rather than putting folk in jail, citations that you indicated, different diversion programs, deflection. That trend started not in 2016, 17, but prior. Is that correct? When do you know what year it is that we started seeing this trend nationwide? That's my first question.
So, Madam Chair, if I may answer. I think it's something that has been of concern for a long time. I started tracking legislation in 2012, and I would say that since that time, 2017, 18, and 19, we've seen a lot more substantive legislation. A lot more comprehensive systems-wide reform legislation addressing this portion of the criminal justice system in those recent years. I'm not sure I could correlate that sort of legislative tracking that I've done with the data that you see here from the Bureau of Justice Statistics, but I would say that 17, 18, and 19 have been the more comprehensive years where we've seen substantial reforms enactments.
Perfect. And the reason I reference that is that it appears that if we look at 15, 16, and 17, that the amount of individuals or inmates that we have it appears that it's going up based on the data. And if that's when new legislation was implemented, I'm trying to find if there's a correlation. If the objective of the legislation was to decrease the amount of individuals that would be in jail, why we see that going up. Now, I do see that in 15, 16, and 17, there appears to be a decrease in convictions, which is great, and the unconvicted rate dramatically went up based on the data that we're looking at in Figure 1. But I'm just trying to understand why there's also more individuals that were in jail to begin with, if that's when legislation was starting to be enacted, and it should have done something like this. It's just what I'm presuming. If you have any, I don't want you to have to answer that on the spot, because I know you would have to go through it, but I would appreciate any insight to that.
Certainly. My only immediate comment that I would say is oftentimes, the enactment may have been put in place in 2017, but there's usually delayed lag time for implementation and training. So it's going to take a while before everything is fully operationalized and you'll start seeing impacts. I will say that one of the important components of large systems change legislation has also been monitoring that progress in individual states. I know that New Jersey has some research out both from the Administrative Office of the Courts and also outside independent organizations who have evaluated their data on impacts that their changes have had on pretrial populations, and they have seen significant reductions. So at the state level, you can maybe see some of those outcomes. But nationally, I'm not sure we can use the national numbers to reflect a handful of states that have made substantial pretrial changes.
So I have just a couple of questions for you, and my questions relate to the states that are offering pretrial services. Does NCSL have any information on the average cost, let's say, to a defendant to participate in these pretrial services for the states that don't offer it as part of a state agency?
NCSL does not have that data because it's so hyper-localized. I could maybe put you in touch with a couple of local examples. And it would depend on level of service as well, I would imagine, but that's not something that NCSL's been able to collect, no.
Okay, and am I correct in understanding that in the states where it's not offered by a state agency that defendants are paying out of pocket for the service?
Not necessarily. That also varies pretty wildly by state and local jurisdiction, depending on the administrative setup and where pretrial services is housed, whether or not it would be fee-based or not.
Okay, thank you. And just kind of a high-level question. I know we've noticed there's a lot of trends in reforming pretrial release conditions. Have there been any corresponding trends in violent crime across the country, or has NCSL ever been able to put together any type of correlation between these reforms and the occurrence of violent crime in the country?
NCSL does not have that data, Madam Chair. Certainly it's something that has been of issue and concern to lawmakers in states that have carried out pretrial reforms, but that would, we could maybe at best provide a local state example or connections in a state.
Are there any other questions at this time? Okay, thank you so much, Ms. Widgery, for coming. We appreciate all of the information, and I'm sure we'll be on NCL's website quite a bit.
Thank you for your
With
time
that,
today.
thank you so much. With that, we'll go ahead and close agenda item number 7. And we'll roll right into agenda item number 8, which is an overview of Nevada pretrial release, including the bail process and bail schedules, the background of ADKT 539, and the implementation of the Nevada pretrial risk assessment. We have Mr. McCormick, who is the Assistant Court Administrator at the Administrative Office of the Courts up there in Carson City. Good morning, sir. Thank you for being here. And go ahead and begin when you're ready.
Thank you, Madam Chair. Again, for the record, my name is John McCormick. I'm the Assistant Court Administrator at the Supreme Court AOC. And you'll note on the slide that it advertised Jamie Graddick, who's our Rural Courts Coordinator, would be here, but she had another commitment that came up after we had agreed to present, so she is not available. I've obviously stopped me and asked questions as we go here, because I've tried to cover a lot in this PowerPoint or in this presentation. But I'd like to start with just sort of the principle of that informs all of this, and it's found in a case from 1895. But basically, there is a presumption of innocence in favor of the accused, and that is at the foundation of our system. So I think we need to approach looking at bail and pretrial release through that lens. What is bail for? And bail serves two purposes. Basically to ensure the defendant's appearance in court and to protect public safety. Protecting public safety is a bit more of a problematic question, I think, as you're all aware, and that's where a lot of the focus on pretrial release has been lately, nationally and in Nevada. Some background as far as case law. Bail determinations have to be based on standards that are relevant to assure appearance and have to be individualized to each defendant. And I think that's where we've seen a lot of issues come up, is those sort of discussed in Varden versus City of Clanton, which is a case out of the U.S. District Court for the Middle District of Alabama. Sorry. But basically the idea is that it is a 14th Amendment violation to incarcerate individuals pre-trial simply because they cannot pay for their release. So indiscriminately forcing defendants to pay for their release is a constitutional violation, obviously. And just of note, there are a number of other cases sort of floating around in the federal system regarding bail. Walker versus Calhoun, Georgia jumps to mind. And I would be remiss here to not say that the 14th Amendment doesn't have an opt-out clause. So we have to keep that in mind as well. In Nevada, a defendant must be admitted to bail unless that defendant is charged with basically first-degree murder, some murder that could be result in a capital sentence or in life without. And that's in Article 1, Section 7 of the Nevada Constitution. Another exception to bail in the state is felony parolee probationer who are arrested for a different offense cannot be admitted to bail. There are some misdemeanor violations that have a mandatory 12-hour hold, i.e. the defendant cannot be admitted to bail before 12 hours. One of the difficult things in talking about our system in a number of facets, not just pretrial release, is that Nevada is a non-unified judiciary. So the local courts retain a great deal of discretion in how they handle various matters. And also, as of note, and this case is still under consideration by the Supreme Court, but in September a case was argued, Valdez-Jimenez versus District Court, which deals with cash bail in Clark County. And the Supreme Court, as I said, is still considering that, so we don't know what the outcome of that will be. The statutes governing bail in Nevada can be found in NRS 178.483 to 178.458 inclusive. And in there, you'll also find that there are some mandatory bail amounts for domestic violence offenses, and certain considerations that also have to be taken. In 178.4853, a judge is required to estimate the probability of conviction when setting bail. That one struck me as kind of odd as I was refreshing my memory about these statutes. 178.498 requires the judge to consider public safety in setting the amount. And also, as the representative from NCSL mentioned, Marcy's Law has an impact on this. It's Article 1, Section 8A of the Nevada Constitution. I don't remember the specific subsection, but it does require the safety of the victim and the victim's family to be taken into consideration when the court is considering setting bail or other conditions. Types of bail, for lack of a better term: bail by surety, bond, and I think everybody's up to speed on that. You go to a bondsman, pay a certain amount, they bail you, and then sort of watch out over the defendant for lack of a better term, is in the run-up to the trial or other proceeding. Cash bail, obviously your bail's set at a certain amount, you pay cash, court holds that, you're released. Release upon a defendant's own recognizance, and this is, I think, particularly in listening to the NCSL presentation, a lot of states are going that cash bail is not necessarily the proper instrument and that a defendant should be released on their own recognizance, obviously with conditions, and I think Chair Harris's most recent question hits on that sometimes these pretrial conditions do have a sort of a financial element attached to them. If it's say, like a GPS ankle bracelet, for lack of a better term, if there's payment there. And as I hit on that, just to note that in Nevada, there's a limited amount of jurisdictions that do have a sort of pretrial services officer. You see that in Clark County, in Washoe County, Carson City, Lyon County, but a lot of jurisdictions don't have that availability of a pretrial services department or Department of Alternative Sentencing to kind of monitor those defendants before. So that's perhaps one impediment to doing more OR and setting conditions. Bail schedules. This is where a lot of jurisdictions have found themselves getting in trouble or getting sideways with the federal court system. And I break this down here because we have misdemeanor citation bail schedule. So that's a bail schedule basically that sets the presumptive sort of fine amounts for traffic tickets. So this is why when, and I'm going to assume none of the members have ever received a traffic ticket, but when you do receive a ticket and it has an amount that you can pay, sign the back of the ticket, check it, I forfeit, and send it in. That's that misdemeanor schedule that sets those amounts for citations generally. And we have done some work to unify those. If you get a ticket between Lovelock and Wendover on the on I-80, that group of courts has done a lot of work to sort of standardize their schedule so the ticket costs the same amount in each jurisdiction. But that's another thing, another topic I'll bring up. And then we have sort of more that general bail schedule that the jail has, and this is the presumptive bail that is attached when a defendant's arrested for various offenses. However, as we've seen in the case law and as best practice, that amount has to be reviewed by a judge, ideally, and set after an understanding of all of the conditions of the defendants, including if that defendant is indigent, their ability to pay. Because this kind of schedule and no flexibility or review is what we see when we're looking at sort of the most egregious examples of people being in jail pre-trial solely because they cannot afford to bail. And I think that's where a lot of the focus nationally has been on this, as far as what purpose is that serving? Does it advance the interests of society in terms of public safety? Also, let's see here, another plug for NCSL, I just have to give this. We also discussed some of this bail schedule issue, and particularly misdemeanor fines and fees at a recent consortium that I was invited to go to with Assemblywoman Bacchus, a couple judges, and the director of DMV. So again, I just want to kind of express appreciation for NCSL giving me that opportunity. So that's sort of an editorial comment while I have the floor. Presumption of release, and NCSL, excuse me, I forgot her name, the representative from NCSL kind of covered this, that there is a presumption for a release on own recognizant or unsecured bond unless the judicial officer makes an individualized determination. And so again, we see that coming up, that's a key element of this, is the judicial officer has to make that individualized determination. And the federal government kind of started this ball rolling, particularly in the federal system. There is that presumption going back to 1984. Just a quick rundown of some statistics that I believe came from a study from the Arnold Foundation. I don't have the citation here, but I can provide that if you would like. But basically, defendants who are held in pretrial detention have less favorable outcomes than those who are not detained, regardless of charge or criminal history. Less favorable outcomes, obviously there's a greater tendency to plead guilty to secure release, and this is a significant issue in misdemeanor cases. The classic example of this, I think, in our state, and it dates back a few sessions when particularly before AB 236, when our definition of burglary was entering anywhere with the intent to steal something. Someone goes into, the gas station, steals some M&Ms, technically charged as a burglary. They sit in jail. It's a Cat B felony. They can't bail. They're offered a plea down to petty larceny, take it, time served and out. So that obviously encourages folks to take that plea or plead guilty to get out of jail. There's a greater likelihood of conviction if a person is in jail pretrial because they cannot bail, greater likelihood of being sentenced to terms of incarceration. Also, there's a likelihood of longer prison terms. So there's a lot that goes with that pretrial detention and being in jail. And I think, again, NCSL pointed out that about 75% of folks in jail are awaiting trial. And also, if the defendant's in jail, they can't really help with their defense, as is key to that fair trial. Public safety, and this again is from the Arnold Foundation. The more time you spend in jail, the greater risk you are for new criminal activity, including low-risk defendants spend more time in jail. There's a greater risk that they may engage in future criminal activity. And so high-risk defendants, though, days in detention categories are not predictors for new criminal activity for high-risk defendants, but those low and mid-level folks who are probably the targets of some of our efforts in finding out how to better use pretrial detention, better get people out, are impacted negatively by spending time in jail. So with all this in mind, the National Conference of State Court Administrators, COSCA, I may say that again, so came out with a position paper based on evidence-based pretrial release, encouraging states, judiciaries to look at implementing a evidence-based pretrial release system because, again, as we've discussed, for poor people, bail means jail, and COSCA, again, thought that was inappropriate. This paper, the position paper issued by COSCA, was endorsed by the Conference of Chief Justices. So, again, the two prominent sort of national leadership groups for the court system have endorsed examining bail and implementing evidence-based pretrial release. And then in 2015, the Judicial Council endorsed creation of a committee to study evidence-based pretrial release in Nevada. When that committee was convened, Justice Hardesty was the chair of this. Obviously, I think you're all aware that he has a substantive interest in criminal justice reform. And so the charge to the committee was to examine alternatives, improvements to the bail system through evidence-based practices and the role of risk assessment tools. The membership of the committee, again, as generally we do when the court has a committee or commission, tried to make it up of interested stakeholders. So we have obviously urban and rural judges, limited jurisdiction and general jurisdiction, PDs, DAs, the Association of County, pretrial service departments, particularly Washoe and Clark counties, county managers, again, to discuss this and see what sort of recommendations we can come up with. The committee obviously received a number of presentations regarding pretrial release, et cetera, and you can see those listed here. I will mention that Kentucky, which is a unified judiciary, their Administrative Office of the Courts actually handles pretrial release statewide. And that's a substantial part of their operation, and the funding they receive is to handle that. Again, and also during this, the commission heard presentations from representatives from the bail industry. The committee at this point, the committee needed to select a pretrial risk assessment tool that would fit the needs. And so the committee worked with the National Institute of Corrections to determine how we would come up with that. And then Dr. James Austin, the JFA Institute, from representative from OJP, et cetera, presented to the committee, and also worked with the committee to create a Nevada-specific risk assessment tool. And that project was headed by Dr. Austin, and that's the Nevada Pretrial Risk Assessment Tool, the NPRA. Obviously, we'll refer to that. And so that study and that instrument was created, and it was validated, and the committee voted to implement it on a pilot program basis, and provided training, and the pilot programs launched in the Washoe County courts, so particularly Reno Justice Court, Reno Municipal Court. The Ely Justice Court is the rural pilot site, and select Clark County courts, including Las Vegas Justice Court. I think one of the things to highlight here is in Washoe County they have pretrial services, and in those Clark County courts they do. In Ely they don't, and Judge Stephen Bishop of the Ely Justice Court actually ended up filling out the risk assessment himself. So you can see there's a variety of sort of resources in the way we can handle this across the state. In August of 18, the committee, based upon the success of the pilot program, voted to go forward with suggesting to the Supreme Court that every court adopt the use of a pretrial risk assessment tool. That ADKT petition, and when I say ADKT, I mean administrative docket petition, and I ask your indulgence if I say ADKT a bunch. But anyways, Justice Hardesty filed that petition requesting that. In March of 19, the court issued an order under ADKT 539 requiring statewide implementation of a pretrial risk assessment tool. And it said within 18 months of the date of this order, so that's roughly September 21st of this year, each court in the state will have to use a evidence-based pretrial risk assessment tool unless the AOC, based on good cause, finds it necessary to grant an extension. In this order, it also required AOC to develop training materials regarding the use and implementation of the NPRA, and educating judicial officers, court staff, and interested individuals in the use of the NPRA. And so we developed that online training and put it together, obviously with 3 distinct I guess modules for each of those audiences. If anybody on the committee has an interest in reviewing that, go ahead and reach out and we'll see if we can get you a log on so you can go on and review one of those trainings. But that's been implemented, and we're following up with courts to ensure that everybody's taking that training to understand this. Here you can see, and not the greatest picture because I jammed them into that slide and would be happy to provide the full-size documents, the 2 choices for the Nevada Pretrial Risk Assessment Tool. The versions are very similar and equally predictive, and both allow for overrides. So in reviewing this information, the judge can override one of these factors. But the idea here is to provide evidence-based information to the judge to use in setting conditions for pretrial release by obviously assessing the risk level of the defendant. There's an 8-question version and a 10-question version. The 8-question version has a few sort of, for lack of a better term, protective factors in one question, including residential status, verified phone numbers, and other stability factors. And the 10-question version has these as individual factors. So obviously it goes in a low score. The instrument would indicate then to the judge that individual is low risk of reoffending, low risk of failing to appear, can most probably be released on their own recognizance with limited conditions. And then we have mid and high level scores as well. The committee to study evidence-based pretrial release, that's a mouthful, received a lot of TA and recognized that here with the JFA, the Arnold Foundation, Institute of Corrections, Pretrial Justice Institute, and OJP. And if you're interested in more information on the specific Nevada assessment, you can find that on our Supreme Court website, it's on our Committee and Commission overview page. So that's my sort of 10,000-foot overview of bail in Nevada, as well as the work that the Supreme Court's committee has done as far as implementation of a evidence-based pretrial risk assessment.
Thank you, Mr. McCormick. We appreciate your presentation and the information on the current status of how bail reform is working in our state. Do any of the committee members have questions for Mr. McCormick? Senator Scheibel.
I want to echo the chairwoman's thanks to you for this comprehensive overview. And I want to get kind of to the NPRA and the process that the committee went through to develop it and to adopt it. And specifically, I'm wondering about the feedback mechanism as somebody who uses the NPRA in daily life, because I noticed that it was in 2018 that the committee decided to recommend that all courts in Nevada use it, and then in 2019 they issued the order that we adopt it statewide. And I'm just wondering, how did the committee determine that the NPRA was working, or that the people who used them in the pilot programs liked them?
Thank you, Senator. That was determined particularly in a series of meetings as the pilot project went on, in reports back from the pretrial services officers in Washoe and Clark County, and as well as feedback from Judge Bishop. And I believe Dr. Austin re-verified the assessment during the time. So it was that feedback and information was provided by the pilot court sites to the commission for its consideration in making that recommendation.
And so you might not know the answer to this question, but at the pilot court sites, did they get feedback from attorneys and judges?
It is my understanding, again, sorry for the record, John McCormick. It is my understanding they did. I know the judges of the Reno Justice Court and Reno Municipal Court were very involved in the pilot site and assessing it and how it's worked, and have provided that feedback. Unfortunately, I did not staff this commission. Jamie did, and so she would sort of be more knowledgeable in terms of the actual discussions there, but you can find the minutes, etc., on our website.
Okay, thank you.
Vice Chair Nguyen.
Hi there. I may have to follow up with her. I don't know if you have this information. I remember, like, even before it was implemented or as a part of the recommendations from the Office of Courts, that things have changed. Like, I know that at one point you had to have a landline, and if you didn't, you were assessed a point, and I see that that has, like, evolved. In some places it's been taken out, or they've included cell phones and those kind of things. And you had talked about how this was evidence-based. Where was this data, like, taken from to show that this was effective in it being included in there?
For the record, John McCormick, Dr. Austin worked extensively on that, and I don't know the specific sort of machinations that were gone through to assess effectiveness, so honestly we'd have to kind of get back to you on that, because I believe Jamie would be better equipped to answer that question, and I don't want to blather on and give you inappropriate information. So we'll get that and send it to you and the committee.
That would be great if we could get that online. I know I was a part of the presentation of the doctor when he presented the information, and I had concerns back then. I think that was like maybe 2015, 2016. But I think it would be helpful for the other members of the committee to get that. Thank you.
Any additional questions from members? Okay, Mr. McCormick, I have just one question for you, and hopefully it won't be too detailed as well. Are you aware of any statistics on potential disparities that were revealed throughout the course of data collection? Or do you know if it was considered, or where I might be able to find any information on that?
Thank you, Senator John McCormick, for the record. I know bias was considered, and Again, I don't have the specific data in front of me, so we'll round that up and get it to committee staff to share with everyone on the committee. I know there was some contention that pretrial risk assessments in and of themselves may have an element of intrinsic bias because they consider previous convictions. And as we all know, people of color are more often or disproportionately arrested, convicted, etc. So there is that element, but I will have to sort of dig into that and get back to you because I don't want to necessarily provide you with bad information.
Understood. Thank you. One last call. Okay, thanks so much. We'll go ahead and close out agenda item number 8 and move on to number 9, which is going to be a discussion of potential topics, dates, and locations for future meetings. At this time, I wanted to just open it up to committee members to discuss a little bit about other topics we might want to consider in our future meetings. For our next meeting, our very next meeting, it's my hope that we will be able to invite a majority of the stakeholders in this discussion who weren't able to present today, such as the District Attorney's Office, the Attorney General's Office, public defenders, private counsel, law enforcement, ACLU, judges, the bail industry, and any other individual and affected communities. I wanted to make sure that we hear from everyone and that we get all of the important perspectives. But at this time, if any committee members have recommendations on other topics they want to make sure we hit on in future meetings, I'd be happy to hear that. Assemblyman Roberts.
Thank you, Madam Chair. I'd be really interested in some data from our local jails. When I worked for Metro, jail space was a significant issue for us, and we worked diligently for an assessment tool, which actually was adopted in other places, and tried to just keep our most violent offenders in the jail and get as many people out as we could. And so a lot of people have done a lot of good work in this area. I'd like to see some data on where we are in Nevada and how we match up. I mean, we heard national trends, but maybe we're doing it right in a couple places, and maybe there's some places that we're doing it wrong. And I'd be real interested in numbers, on how it impacts us here in our state, if we could get that from jails or the folks that have that data.
Thank you so much. Yes, I agree that would be extremely helpful, and we'll have LCB reach out and see if we can get those numbers, or if not, invite some people down who might have the information for us. Senator Scheibel.
I think that the co-responding programs are incredibly important, and that I know that they're relatively new, so we don't have a lot of data on how well they've been working, but while we were sitting here, I did do, some preliminary research into Colorado and some other communities that have started using them, and I think it'd be great if we could get a presentation from either a community that's using one or someone who has some best practices, and think about whether that's something that could be effective in any of our communities here in Nevada.
And what was that you wanted to look at again?
Co-responding programs.
Co-responding programs. Okay.
Where, just to clarify, that's where law enforcement officers and mental health professionals respond to an emergency call at the same time, so that if someone's having a mental health crisis, they can be diverted to services rather than being arrested.
And I believe we have the LEAD program here, at least in the metro area. Okay, great, thank you. Assemblyman Flores.
Thank you, Madam Chair. Some of the data that I'd be interested in looking at is in the areas where we don't now put folk in jail, for example, traffic tickets and some low offender misdemeanors. If we can get the data of how many of those we have per year, and then out of those individuals who get that traffic citation and or some of those misdemeanors where we're not putting folk in jail, if we can get data as to how often they show up to court, so that we can link that correlation. There's areas where we can look at now where there's this idea that folk will only show up to court if you put them in jail, but I think we can look at other areas where we're not already putting folk in jail, and we can see if that's actually true, because I think the last time I heard some data on that, folk in fact were showing up to court and were paying their tickets. So I was curious to see that, and if I have that data in front of me, I think it'd be helpful. Thank you.
Senator Hammond.
Thank you, Madam Chair. I think the presentation today was helpful and sort of in my mind, looking at the number of years that this movement has been in place, and the number of laws that have been enacted, across the many states, and then also talking about some of the walk back that has occurred. And as interesting as that might be, I'm sort of interested in knowing more of the what have some states changed since then. So I think because we're coming into this now and really getting focused, I think we're going to be the beneficiaries of what other states have done, and where, if we're talking about that balance between, the public safety as well as making sure that we're helping those who seem to be in need of help, as well as, they've committed something or may have committed something. We want to try and figure out where that is. Well, there's a balance there that needs to be struck, and I think that we might benefit. So I'd like the fact that we talked about it today, but I'd like to know more about, not necessarily, I'd like to know more about some of the laws that were rolled back, but more so what changes, what minor changes have occurred in many of the states since they enacted some of these provisions. So I'd like to kind of do a deeper dive into that.
So maybe there is thank you, Senator Hammond, maybe there's an opportunity to explore whether there are any states who have felt like they went too far and wanted to curve back, and then simultaneously take a look at any trends that you may see from states that have made particular changes, whether those trends be in a good direction or not, so that we have that information in front of us.
Exactly, and of course the associated data that may have spurred that change, or any kind of data that can say, well, this is why we kind of looked at it. It's better than anecdotal stuff, I think.
Any other thoughts from committee members at this time? Assemblyman Flores.
Thank you, Madam Chair. The other thing that I was interested in looking at, when we speak directly to the bail bond industry, one of the things that we often, it's anecdotal for me, I don't have any data on any of this, is the relationship between the bail bond companies and the individuals that utilize their services. I often hear that there's either these overburdensome requirements that are imposed on the individuals that utilize the bail bond services by the bail bond company directly that goes beyond ensuring that they show up to court. It's anecdotal. I don't have any of that, so if I could just hear the practices from the bail bond companies, what are they doing? What requirements are they forcing individuals to go through? And that would be very helpful.
Thank you for that. I agree, and as we reach out to stakeholders, I'll be sure to ask bail bond representatives to address some of those conditions that they traditionally place on defendants before issuing bond. Yeah. Okay, so one other item of business before we move to public comment, and that will be scheduling our next meeting. And rather than have all the members pull out their phones right now and schedule a time, I will ask the committee secretary to send around an email and do a informal doodle poll of sorts to the members, so that we can get our next meeting on the schedule as soon as possible. I anticipate that it'll be approximately 4 to 6 weeks from today. Held here in video conferenced into Carson City. So please be on the lookout for that email and go ahead and start scheduling some time for this committee meeting in the future. All right. We'll go ahead and close agenda item number 9 and open it back up for public comment. Because of time considerations, speakers are urged to avoid repetition of comments made by previous speakers and made earlier this morning. A person may also have their comments added to the minutes of this meeting by submitting them in writing, either in addition to testifying or in lieu of testifying. Written comments may be submitted in person or by email, fax, or mail before, during, or after the meeting. And it looks like we don't have anyone in Carson City quite yet, so we'll go ahead and start down here in Las Vegas.
Leslie Turner, for the record, Plan Action, the Mass Liberation Project. I'm sorry, I'm like getting over a cold. One of the things, first of all, thank you for this committee. The community explicitly asked for this committee in our letter to the Senate in the legislative session. And I just wanted to say that this is not like the community versus the bail bonds industry at all. This is about systemic change and changing a system that inherently is designed to create this kind of disparity, and that's really the core of what we're trying to change. I think that in this, we've just entered a new decade. I think that we have the ability and the innovation and the creativity to really start thinking about how we define public safety. And that's why it's really important, and I thank you, Madam Chair, for including the community as a stakeholder, because historically I have not seen that here in Nevada, where we're actually included in those discussions and those negotiations, because I think it's important that the community gives feedback on what keeps us safe. And I think that we need to dig in a little deeper on how we define public safety and what it actually even means when we say that, because we're thinking about, because that seems to be the key thing everyone spoke on is, keeping the community safe. Okay, well, talk to the community and see what actually keeps us safe. So that's pretty much it. I just thank you. I'll be engaged. I definitely want impacted people to be able to have a seat at this table. So hopefully I'll see you guys all again soon. Thank you.
All right, thank you, Ms. Turner.
MJ Ivy, Ivy's Communications, former Vice President of the Southern Nevada Officials Association, Pentecostal Assemblies of the World, Nevada State Director, and a veteran of the United States Air Force serving in Desert Shield as a Storm. I am very happy that this committee is here, but I have a couple of questions in regards to why veterans are not being issued any type of understanding when it comes to the accession of a veteran that may be incarcerated. The reason that comes up is that speaking with Kim Thomas, the Deputy Director for the state and state safety in our prisons, they have several veteran programs, but when they're getting there, they're not being assessed as veterans while they're in the local jail. So they're not being recognized, and the possibility of a domestic violence situation, that there may be some PTSD involved, and so no health official is there on the scene. Metro, in my experience personally, does not ask, even if it's been identified about being a veteran, is not on any particular pieces of paper when you're processed that you are a veteran. The DMV does a great job of doing this and recognizing that, even charging us $300 for a plate to let us know that we are veterans. But the Metro Police Department does not do that, and the judicial system does not recognize it when we do a PSI. So they do not say anything about our service as to the 10, 15, 20, 30 years retired, multiple service records serving, maybe even for the state in itself, no recognition at all. So that when they get assessed, their levels of being, having jail or having a sentence or even having bail is not even considered whatsoever. The only consideration that the veterans have is a drug court, which is a shame, because 90% of all veterans don't do drugs, more commit suicide than drugs. They're homeless more than drugs. They're good citizens not being recognized, and most of the time, as Mr. Flores I think gave an example of, they steal a box of M&Ms because they're hungry, because they're homeless. And now we turn it into a B felony instead of getting the things that they need done, because most of them don't know where to go and how to get the services they need, because we've intelligently put a hospital approximately 25 miles away where they're living or located at, and they don't have the resources to get there. So I would like this committee to take a look at exactly why veterans are not being considered. what can we do to help them be considered? And people like myself who have been touched by the criminal justice system, and I'm trying to be as polite as I possibly can, because as a man of color who is 48 years of age, who was previously touched by the justice system because I was a threat, and I was told that, and I could not do anything but take a deal. This was in the state of Missouri, the same state of Missouri in which the Obama administration had to shut down certain cities that were doing illegal things to make money, including the bail system. The same Missouri that is going through right now being sued for the St. Louis Police Department for racial injustices, because that's where I'm from. And I'm seeing some of that, not any at all, most, but seeing some of that here. And because I've been here 15 years, going on 16 years, and serving in the capacities that I've mentioned before, I'm very much concerned for my citizens who look like me, as well as the young men and women who come after me, and the men and women who served before me as veterans of the United States Air Force and the military itself. Thank you so much for letting me comment. I appreciate you. Take care.
Thank you, sir. We appreciate your time and your service, and I think I can speak for all the committee members in saying that we will definitely be keeping veterans in mind as we think about reforms to the system. Thank you.
Madam Chairman, my name is Robert Langford. I'm a private practice attorney practicing here in Las Vegas. I also host a very broad-based coalition of communities at my office. We meet at least once a month, and we're going to probably crank that up a bit. That coalition consists of Plan Action and a couple of other communities, Faith Alliance community, but also then on the very far right, Americans for Prosperity and the Nevada Policy Research Institute. Because I'm here today to say thank you for listening to the resources that you've already listened to, and just know that this politically and philosophically, bail reform is supported by every think tank that's looked at it, save and except, of course, the bail community, and, you know, that's going to hit them in the pocketbook. But if you look philosophically, whether you're a fiscally conservative person who looks at this as just a huge waste of money that doesn't get us the results that we want as a community, or whether you look at it from a community that is unfairly impacted by the current bail system, everybody says there's something wrong and it can be fixed. I would invite you to look particularly at those organizations that were cited by the Administrative Office of the Courts. They are fantastic resources dealing with this issue, and they can tell you a lot of things about what other jurisdictions have done by way of bail reform, how different Nevada is in a lot of ways from other jurisdictions, and what Nevada specifically needs to do. There are good programs, as Assemblyman Roberts pointed out, there are good programs around the state that are headed in the right direction. But as the Administrative Office of the Courts pointed out also, we are not a unified judiciary. And at that point, it's probably got to be something that the legislature has to do. Again, thank you for holding the meeting, and just know that there is a broad support philosophically and politically in this particular area. Thank you.
Thank you, Mr. Langford. Are there any others who'd like to give public comment at this time? Okay, seeing none, we will go ahead and adjourn. Please keep an eye out on our website for the next meeting date so that everyone is involved. Share the information widely, and we hope to see you all and a bit more at the next meeting.